Okay, good morning, thank you. We're live streaming from a press conference at the law offices of Cold Partners. We'll be getting started in just a couple of minutes with the press conference. Thank you for waiting. Let me know when you're all ready to go. And so again, for those people on Facebook watching the live stream, we're here at the law offices of Cold Partners in downtown Toronto, ready to do a press conference. We'll be starting in just a few minutes.
How's my exposure?
Is it possible before we can start?
Just because it's in the camera and it's just enough.
Sure. Stephen Shryman, S-H-R-Y, Stephen with a V, S-H-R-Y-B-M-A-N, who's a lawyer with Gold Law Partners.
Okay, cheers, bye.
Kathy Parks.
I'm not quite ready yet.
P-A-R-K-E-S, Kathy, C-A-T-H-Y. So E-S for Parks, and Kathy's dad was a resident at Orchard Villa.
So if you could help us out when each speaker comes to the podium, they can say the spelling names just as we start.
Okay, sure. Yeah.
Please.
And I'm Natalie Mahoney, N-A-T-A-L-I-E-M-E-H-R-A, and I'm the executive director of the Ontario Hospital.
Yeah, I'm talking to you, man.
Sounds good. So you all let us know when you're ready. I'm just turning off. Now, I got copies of the notice of application.
Omar Tina, good?
I'm good, finally. Thank you.
I'm good.
Thank you, Team Tina.
Look at that. I like being on Team Tina. Get coffee and
It's a good thing.
Can we get your email?
could be Brian, Doug, and
I think I should have stayed
Tina.
with
Team
her.
Brian, Doug, and Tina.
Yeah.
I like that too.
I have mine.
Yeah. Yeah.
So if Alana gets your email addresses, we'll flip this in electronic form to all of you as well. I've got one more here.
Cute.
And you need that for now? Okay. So again, for those on Facebook, we're live streaming, just about to start a press conference. We're at the law offices of Cold Partners in downtown Toronto. Will just be a moment. So I'm going to switch back so we can move in. Okay, and I'll switch places with you, and then you switch that way.
We're all good to go here.
You're all good? Everyone's ready?
Yep.
Okay, wonderful. My name is Natalie Mehra, N-A-T-A-L-I-E-M-E-H-R-A. I'm the Executive Director of the Ontario Health Coalition. Thank you all for being here. We're here because we're announcing that we have taken legal action against the province of Ontario for moving forward with granting a new license and expansion, significant expansion, to Southbridge, which is a for-profit company that owns Orchard Villa. And I'm going to introduce you first to our lawyer, Stephen Shryman, who's going to tell you about the legal case, what it is, and what it's about. And then Kathy Parks, whose father passed away in Orchard Villa and is part of the families of Orchard Villa. And then I'll close it up, and then we'll open it for questions and answers. So this is Stephen Shryman, and he's a lawyer with Gold Partners.
Good morning. I'm a partner here at the firm and have been for almost a quarter of a century now. What I'm going to do is give you a very, very brief description of what it is that we're asking the Superior Court of Ontario to do, and say a word or two about the timing of the application and when we expect it to be heard. A little louder?
Yes.
Okay. So I'm going to give you a little overview of the case, a very deep overview of what it is that we're asking the court to do, and a little bit about the timing of how we expect the case to unfold. So our clients have gone to the Superior Court to ask them to issue certain orders. The first one is setting aside a decision by the Ministry of Long-Term Care to approve a proposal by Southbridge to build and operate a new long-term care home on the site of the current Orchard Villa long-term care home. The home would be substantially larger, as Natalie indicated, than the one it would replace, and be licensed for a period of 30 years. So the first request is to review and set aside the decision and approval that the ministry has given to this project. The second is we're asking the court to prohibit the ministry from taking any further steps to facilitate the project, including by providing any capital funding for it. The third is that we're seeking a declaration from the court that the Southbridge project was unlawfully, that the Southbridge project, that the ministry acted unlawfully in approving the Southbridge project for several reasons. First, by deeming Southbridge eligible for a license given its persistent record of regulatory noncompliance and of causing harm to the residents entrusted to its care. Two, by finding that in the face of Southbridge's disastrous record, it would be in the public interest to reward it with a new and expanded opportunity to operate a long-term care home. That's an unlawful conclusion in our view. The third is by denying procedural fairness and violating the rules of natural justice by failing to notify and meaningfully consult with the applicants, other family members of Orchard Villa residents, or the public in general, and by announcing its approval of the project without offering any reasons whatsoever for doing so. The ministry also, it is our contention, failed to consider the values of the Canadian Charter, and in particular, the right to life, liberty, and security of the person that's enjoyed by people who are residents of long-term care homes, and failed to engage in a consultation process that reflects the importance of according fundamental justice to all those concerned about decisions that may affect, as we believe this approval will, the life, liberty, and security of residents who are entrusted to the care of the Southbridge company. In essence, these grounds arise from the provisions of the Long-Term Care Act, which require the ministry to consider the past record of anyone seeking a license to operate a long-term care home, and to determine whether it can be reasonably expected that an applicant comply with the law and the regulations under the Long-Term Care Act and reliably provide for the proper care and safety of long-term care residents. That's the test of the Long-Term Care Act. So the ministry officials are directed to consider the past record of the company and whether it can find in that record any reason to be confident that the company will comply with its obligations under the Act and properly care for residents. For reasons that Natalie and Kathy are going to describe, our contention is that there is absolutely no reasonable basis for considering Southbridge to be eligible to operate a long-term care home. The legal proceedings I'm describing are initiated by filing something called a notice of application, and you all have a copy of it. It describes the orders that we are seeking from the court, and I've just described those very briefly. But it also sets out at some length the grounds upon which those remedies are being sought. So the last thing I'll say is that the timing of all of this is that on March 15th, we will get a record from the ministry filed with the court which describes what it did in what it took into account, what documents it had before it, in making the decision to approve the Southbridge project. There's no transparency whatsoever at this point about any of that. Even the application by Southbridge wasn't available to people who ostensibly were consulting about whether this project should proceed or not. So we'll get to see what it is that the ministry did or didn't do in considering this application when it was presented to it for approval. And that'll happen mid-March. Then there are several things that happen that won't be very public, including cross-examinations on the evidence that we will adduce and that the ministry is likely to respond with. But we do have a date for the hearing, or we hope we have a date for the hearing. It's a date that both the ministry and we have agreed would be ideal, and that is the middle of October, October 14th, 2024. So hopefully the case will be heard then, and we would hopefully have a decision by the end of the year.
Thank you.
My name is Kathy Parks, CATHYPARKES. I am a member of the Families of Orchard Villa, Canadians for Long-Term Care, and this all began because my father was a resident in Orchard Villa. He passed away April the 15th, 2020, during wave 1. Since my father passed away, I have found myself having to speak up more and more, specifically in regards to Orchard Villa and what was going on there. I was in the home, visiting my father several times before he passed away. I saw how the home was run. I knew about the incident reports and I don't know how you'd say I knew about what the home was like before moving him in there. I saw how bad things were, but I think a lot of people who deal with long-term care find that you end up not getting much of a choice, especially when your loved one is in critical care. So the last 4 years, we're almost up to the 4th year anniversary of my father's death, and a lot of other people who lost their loved ones in that home during the pandemic. During the last 4 years, unfortunately, I've had to become an advocate for Orchard Villa, for the families, and for myself to try and see some changes in long-term care. We spoke at public hearings in regards to this license when the government held 2 public hearings, one by email, one by telephone. We went to the city of Pickering to try and stop an NZO that was granted to Southbridge for this home. The city of Pickering voted unanimously against the NZO, and yet it was still granted. And I find that I'm at a loss for words as to how this home can be granted a license to go ahead with the new build, not only for an extra 87 beds, but the potential of over 800 beds. When you look at their record, at the incident reports that are publicly available, you can see that they were having trouble before the pandemic. You can see from the military report and the news reports what happened during the pandemic. And then that has not been corrected since the pandemic, since wave 1 of the pandemic. If you look at the incident reports, it's quite detailed that they're continuing to fail in infection prevention and control, in restraining residents, in not having clean linens. Everything that was always present is still present. Things that were found in the military reports are still present. And yet, without warning, without notice, they were granted this step to move forward towards a license and a new build. I'm shocked. And I think the families of Orchard Villa, we've been talking, we're all shocked. And I think the public deserves better. I think that residents of long-term care deserve better. I've heard this government say, the Ford government say that it's about we need more beds. I don't disagree with that. But I think when we're giving up a quality of care just for numbers of beds, we're running into a really big problem. And if we have not learned anything during the pandemic about how we treat long-term care in this province, we're losing. And so that's why I decided to join to sort of challenge this decision that was made, and I'm hoping that we can move forward with it and have a reversal, because I think that people who are currently living in Orchard Villa and in all long-term care homes in Ontario deserve better.
So again, it's Natalie Mehra, N-A-T-A-L-I-E-M-E-H-R-A. I actually, it's hard to think of what happened at Orchard Villa without getting emotional. I mean, that was just in case people have forgotten, it's one of the most notorious long-term care homes in the country. 206 of 233 residents contracted COVID-19, almost everyone, and more than 70 died at a death rate of 30 deaths per 100 residents. That would make it among the highest, if not the highest, death rate in Ontario during the pandemic. The military, when it went in, described the conditions. Mattresses left on the floor so residents couldn't get up and walk around. Their belongings put out of their reach. Residents severely dehydrated and malnourished. Residents left without hydration, improper feeding. Resident with a fractured hip left without treatment or care. Multiple resident falls without assessment. Poor access to supplies. Not only were residents left on bare mattresses without linens, but also scarce wound care supplies, improper use of PPE, oxygen generators without oxygen, broken section, all the suction units were broken except for one locked in the basement. This was the condition that the military found in the home. And if you look at the inspections reports since then, all the way up to 2023, the most recent inspections reports, you see chronic non-compliance and the same types of incidents that were described in the military report running through them. People who've fallen with no post-fall assessments, people who've been hurt with no follow-up care, not being sent to the hospital, no nurse's assessment, improper reporting to the ministry, faulty use of restraints, inadequate medication, not doing the medication properly, all kinds of healthcare problems with the supply of appropriate infection prevention and control, even when the home has been an outbreak, and as I saw this morning, it's listed as in COVID outbreak again. And this continues through to today. It's not like the military report was an aberration for Southbridge at Orchard Villa, or frankly at their other homes. Southbridge just opened a brand new home in Owen Sound, and that home was so poorly run that the ministry actually stopped admissions to that home for a period of time. This is not a ministry that has been actively enforcing standards on long-term care, as you know, and continues not to. And so when they actually stop admissions, it hits the operators, the for-profit operators, in the pocketbook, which is what they really care about, and they can only get their full funding if the beds are 98% full. So, trying to force compliance on this operator. So why then would they issue Southbridge a new license at Orchard Villa? Their own legislation says they cannot do it. It sets out clear criteria. The criteria require that the record of the operator be that there could be a reasonable belief that the home could be operated in a manner that is not prejudicial to the health, safety, and welfare of the residents. And if you're looking for that, it's section 101 of the Fixing Long-Term Care Act. It's their own legislation. It requires that the government ensures that the past conduct of the long-term care home operators is in the public interest, in compliance with the legislation, and so on. None of these criteria are met by Southbridge, and certainly not met at Orchard Villa. To give this operator a big expansion, 87 new beds, is astonishing. To give it a 30-year license is just despicable. And it's rewarding one of the very worst operators in the province. I just want to add two other things. One is that not only have they violated their own legislation in moving forward with the approval of this new license and expansion, but they also have gone to extraordinary lengths to make this happen. The plan is for 3 15-story towers on a piece of land in Pickering. The land is not zoned for that. The plan violates all kinds of zoning requirements, like everything from the setback to the parking to, the size of the buildings, the height of the buildings, and so on. The city of Pickering voted unanimously against it because that piece of land can't possibly service that many residences. And the province issued an MZO, a ministerial zoning order, to override the unanimous vote of the city of Pickering against this redevelopment, to force this redevelopment through on a piece of land that cannot support it. And as Kathy noted, the immediate proposal is for 87 new beds, but the plan is for more than 800 long-term care beds, which would make it possibly, I don't know of any other long-term care home that is that large. I've never heard of an 800 bed. There might be one in Ontario, I'm not aware of it. It would be the biggest long-term care home in the province, a size that no one would support for long-term care. And so the question is, why is this government going to such extraordinary lengths to give Southbridge this license and expansion and potential even larger expansion to be one of the largest long-term care homes in Ontario or in Canada? And then finally, there are lots of other options. The province worked with the hospitals to build 4 fast-track long-term care homes that are public, non-profit, owned by the hospitals. They built them mostly within 2 years. They were quickly built, unlike the for-profit ones that are very slow and behind. It's possible to do that. It's possible to work with municipalities and nonprofits to do that. None of that has been happening, and instead they're moving forward with these licenses to the same chain companies that are responsible for the vast majority of deaths in the pandemic and continued really horrific conditions for the residents of their homes. So that's it for the statements. And does anyone have any questions?
I guess, Kathy, we talked a long time ago about the police investigating what had happened at Orchard Villa. I was just wondering if you ever got a resolution for the police to be here, if they wrapped up, and why?
At the time, what I was told was I had reached out to the Durham Regional Police, and they said they had deferred to the Ontario Provincial Police, and then I never heard anything after that.
And none of the families were ever interviewed by the police. Like, if there was any investigation, not one of the families was ever interviewed. So it doesn't look like there was ever a serious investigation.
Hi, Liza with City News. Premier Doug Ford held a press conference this morning. We asked him about this court application going forward. If I can just give you his response and get you to react to this. He said, I can tell you there were a lot of problems with many homes across the province. We've corrected those. We have more inspectors going in. We are modernizing the facilities.
Well, they haven't been corrected. I think that that's apparent by just the amount of family complaints you can see in the incident reports, by the warnings and the written warnings that they're receiving in the incident reports. Things have not been corrected. As far as investigators, I agree there needs to be investigations. However, even in the incident reports for Orchard Villa, you can see that a monetary fine was issued for non-compliance and then retracted by the director. So if we're not actually following through with what they're promising, as usual, the government is promising, fines and heavier penalties, but then there's zero follow through. So that just sends the message they can do whatever it is that they want. But I can tell you from talking to family members and people who are still living in there right now, things are worse. This is a quote from a family member than they were before the pandemic.
If you prevail here, how would it change the way this is done in Ontario?
If we prevail, how would it change the way things are done in Ontario?
Well, hopefully, the ministry will begin to take seriously the mandate that is given under the Long-Term Care Act to actually take a look at the record of the applicant as it's required to do. We'll see what the ministry has done. I'm skeptical that that obligation has ever been taken seriously. And in response, just if I can add something to the whole issue of enforcement, I mean, at the root of this problem is for-profit care. We all know that. The obligation of the company, its first obligation is to ensure a shareholder return, and it will do whatever it needs to in order to meet that mandate. And it cuts against the obligations that owners and operators of long-term care homes ostensibly have to put the interests of residents first and foremost. So, and Ontario's an outlier in this, I think, as you know. There are more for-profit homes in this province than anywhere else in the country. And so it's a bit of a mug's game to hire police to keep an eye on the fox in the hen house, and that's exactly what's happening here. And I think the most important signal that the province has been sending to operators that have failed to meet their obligation is that they will be protected from civil liability. You know that the province has done that. And that no matter how horrendous their record is, they'll be rewarded with a new license. And in this case, an expanded license. So anybody operating in the sector will see this approval and say, well, it doesn't matter how badly we perform. This province will give us a new license. It'll pull out the stops to allow a development approval that we would otherwise be able to get. So it just works at cross purposes with the whole notion of, well, we're going to hire more inspectors. I think we're going to hire eight enforcement officers. That's probably one for every 10,000 residents in long-term care. So it's a convenient device for trying to persuade the people in the province that they actually care about the problems in the sector, when everything else they're doing sends the opposite message.
Can I just add something? You know, we spent years, like literally years, fighting for decades now, for improved standards in long-term care. When the new act was originally brought in 2007, we fought for provisions in the act that would ensure that terrible players like Extendicare had been, moved out of the states of Florida and Texas, and then was up there to Tennessee, I think, because of litigation for terrible care, and then ultimately a big judgment against it by the U.S. Department of Justice for providing care that was so materially substandard as to be non-existent, in the words of the U.S. Department of Justice, and then expanded in Ontario. And after that experience, we fought for these provisions to be in the Act, and they were brought into the Act. And, the law has to mean something. Like, if the law says you're going to regulate this sector, and there's going to be these standards, and those standards have to be upheld. There's 80,000 people living in these homes, and they're frail, and they're elderly, they get hurt easily, and they die easily, and they deserve to have dignity, and they have not been given that, and it has not changed. Orchard Villa has never been fined. They never had a license suspension. Their license was never revoked. Nothing happened to them, even though they had 30 deaths in 100, one of the highest death rates in the pandemic. We spent as a public a fortune sending in the military inspection teams. They've been repeatedly cited, chronically cited for non-compliance. Nothing happens to them. And now they get a new license and a massive expansion? No. In what world could that possibly be right? And it's not like there aren't other choices. This is about giving private contracts to private companies, and absolutely not about the public interest.
Kathy, you mentioned that there's potential for 800 beds. Can you just clarify that? Because there's the 87 new beds that have been awarded. There's just over 200 long-term care beds currently.
Right.
So how do you arrive at that?
They currently have 233. The original application was for an extra 87 that was bringing to 320. However, there was a point in time in 2021 or 2022 where they changed the name of the license, and in doing so increased the application for the permission to build 832 long-term care beds and over 600 retirement beds. So this new build likely isn't going to cover that. I don't know actually what their plans may be, but their original proposal was for the 87 beds. But this is also a free license to build extra 15-story buildings with over 800 long-term care beds.
So just to clarify, the MZO, the zoning application, the planning thing is for 3 15-story towers and up to more than 800 beds. That's what they've applied for in that planning process. The license that we're going to court over right now is for an expansion of 87, a new license that is larger by 87 beds. So they had 233 beds, it'll be 320 beds. And then the building that they're planning will have the capacity of more than 800 beds.
And so that's including like retirement home beds?
No, 600 retirement home beds, 800 plus long-term care beds, massive. And that's what the MZO, all of that process with the city of Pickering opposing, and the families and, you know, the public generally, that's what that has been about. But the government moved forward with the MZO, and even though it's canceled, or seems to have walked back from some of the MZO, not these Southbridge ones, curious.
Let me just add that the company put out a tender in the spring to retain a construction company to proceed with the project, which it indicates will happen in stages. So there are 3 towers, but I think the first element of all of this is going to be the one for the long-term care home, according to the tender documents. The third, I presume, might be for the other beds it's hoping to eventually be licensed for, but it hasn't applied for more than a license to build one home, I presume one of these 15-story towers that would accommodate 320 residents. It has zoning approval to do more than that. It's hired a construction company with that in mind, but you know, the second and third towers are in the future, and I suppose ultimately the third tower won't be built at all if it isn't given approval for the difference between 320 and the 800 that theoretically is entitled to, at least from a planning point of view, proceed with. If we succeed, there won't be a project there at all.
So are there any precedents for the courts overturning an MZO?
I don't think so, but I don't know the MZO law, but I'm not aware of any precedent for a court intervening in a matter of licensing a long-term care home. So I think this will be unprecedented, at least as a test of the provisions that Natalie described were the result of a lot of public advocacy that the ministry take the licensing process seriously.
But sorry, you're also asking the courts to overturn the minister's vote. No, you're just asking the courts not to grant the license for the new beds.
Just that.
Our warning really about the MZO is kind of, the issue of the MZO is kind of an addition. So the court challenge is on the license. The MZO is just, you know, why would the government go to such extraordinary lengths for this company to do this, and also the scale of the project is eye-popping.
Obviously not a lawyer over here, but I expect to hear something about how if the legislature is free and makes its own decisions, what will be the argument against that the government has the right to make these kinds of decisions?
Well, the ministry officials have an obligation to administer the legislation that empowers them. So that's the only authority the government has. It has to find that authority in legislation. And this legislation is very specific. When you consider a license, the minister himself has to make a determination that it would be in the public interest to issue this license, and the director of approvals has to make a determination that the company itself is eligible for a license. So they have no authority other than the authority the Act that gives them, and that authority is conditioned on these 2 requirements. For the minister, public interest; for the director, eligibility. And in our view, it is extremely difficult to imagine that this project could satisfy either of those 2 fundamental conditions.
So you're essentially arguing that they broke their own law in those 2 ways. Is that
We're essentially arguing that they were both.
They broke their own.
Oh, they're both, yeah, they absolutely, when we say they acted unlawfully, it means that they acted without legislative authority. So they can't simply issue a license ignoring the requirements of the Act that give them the authority to do that. So you can't issue a license if it's not in the public interest. You can't issue a license to a company that isn't eligible. And in order to determine eligibility, you have to look at the company's past record. Only the company's past record. not its promises about doing better in the future, but what it has done in the past. The Act is very explicit and specific about that. It's unusual in that regard. And I think the provisions reflect the advocacy that the coalition and others engaged in to compel the government of the day to take this problem of licensing companies that are actually able to provide proper care and comply with the law seriously. And now the test is whether or not this government has done that, met its obligation to do that, and the court will determine.
And just to wrap up that thought, the courts have made similar findings, but not in applying to long-term care applications before. Is that right?
Can you speak a little louder? I'm sorry.
And have the courts made similar rulings that you're like the one you're seeking, but not to a long-term care license before, like on other issues?
Well, this remedy is something called an administrative law remedy, which is an application to the court to compel public officials to act in accordance with their mandates and the law that empowers them. So there's lots of litigation like that. It's happened across the country. It's gone all the way up to the Supreme Court of Canada on various occasions. So the court, is empowered to make sure that the law is complied with, even when the authority is being exercised by public officials. And that's the whole sphere of administrative law, and there's an awful lot of jurisprudence about all of this, and the courts have set out a test for deciding whether or not they will intervene in a particular case where the failure to comply and meet mandates or to act in accordance with authority is serious enough to warrant an intervention and order that whatever a public official has done that's unlawful will be struck down.
Can I just mention, because just in case people don't realize that the Harris government was the government that started for the first time in Canadian history that the public would fund for-profit long-term care beds, for-profit companies to build long-term care homes that they would then own and operate for their own profit under these licenses, right? It was initially 20-year licenses. The Liberals expanded them to lengthen them to 25 and 30-year licenses, and that carries on to this day. So when we're talking about all of this, these are beds that are funded, built by the for-profit, but then funded by the public paid for by the public over the 30-year license. And so when so the minister is licensing, the minister and the director are licensing beds that are publicly paid for. The capital is publicly paid for. The subsidies for the operation are paid for by the residents and the public. And that's, so they are required to follow the law that requires that they operate in the public interest in these beds. That's the, if we didn't like that they were privatizing them at all, but if they were going to privatize them, they would at least have some basic level of protection for the residents of these homes. Just to clarify that.
Do you have any thoughts on the timing of the ministry's decision? Were, the horrific stories about the military's findings, it was years ago that they were in the news. There's very little, if any, coverage now. The horrors in long-term care, sadly, are kind of like a distant memory. Selfridge applied.
I think you're right. It's been, long-term care hasn't been in the news, even though the experiences of the families remain and the residents remain terrible in Ontario's long-term care homes. It just hasn't been subject to the same level of scrutiny and coverage that it was a few years ago. Frankly, not much has changed. The staffing crisis remains. The inadequate levels of care remain very serious problems across the sector. But I think you're right. I think one, the long-term care hasn't been in the news, and two, they issued the undertaking for Southbridge to move ahead with the license just before Christmas, at the beginning of December. And under administrative law, we have 30 days to file. So, you know, it looks to us, I mean, it was delayed for quite a long time, and then they did it right in December when it would be the most difficult time for anyone to be able to file this kind of court challenge to it. So, I mean, we can't guess really what their motivations are, but just observing.
Do you know, do other license approvals take years like this one did?
Well, no,
For them to
I
happen
mean,
very
many of them
quickly.
have happened quickly. Yeah.
Well, yes, I think, you know, one of the things we're complaining about is when they issued the license, they didn't notify anyone, other than presumably the company, that they had done that. And that includes the people that participated in the consultation process, and it included me, because I had written to them 2 years earlier saying I represent the Ontario Health Coalition and now Kathy Parks. We have a direct and vital interest in this licensing process. Please advise me of any progress with the license application and any determination of it. I wasn't notified, no one was notified. So how do you even know that a license has been issued? Well, how you know is you go to a ministry website that lists all of the license applications in process, and you go there every single day for the last 2 and something years to see whether the status of this license changes. We did that. And on December 1st, the status changed. That was the only reason we or anyone else knew that this project had been approved. That's not fair. It's not in accordance with any notion of natural justice. And that failure itself, in our view and in our contention, is grounds for quashing or setting aside the approval.
The City of Pickering had councillors yesterday, when Kathy spoke with one of them, they had not been notified that
They
it
had not been
approved.
notified, and the family members had not been notified.
I suppose this media account today will probably bring this to attention of a lot of people who have interest in this, who may not know that the ministry is proposing to give this company a green light.
Is there a timeline for the building and the process of this approval? Do you know? Do you have that information?
No, I don't know that. And there is probably a development agreement that's been negotiated between the company and the ministry, but that has not been made public, or has any other document about this process been made public, but will be on March 15th. And so we'll finally get to see how this happened, what was before the ministry, is there a development agreement, what does it engender, what might be the timeline for this project, what conditions have been attached to the approval. Sure.
And is that because you're seeking, the courts to overturn this? Is that why you will get some information on March 15th?
Yes, under the rules of the civil rules in Ontario, when you file an application, or under the Judicial Review Procedure Act, which is the legislation that governs the kind of application that we brought, when you bring an application challenging a public decision, the decider, the ministry, or the labor board, or the Ministry of the Environment, or whoever it happens to be, in this case, the Ministry of Long-Term Care, has to file something called the record of its decision-making. And that's why we expect it will file a record on March 15th. It's not supposed to take that long, but the ministry has told us it will, because the record will be voluminous, and we'll see what's in it on March 15th. It needs to be filed with the court, so it will be a public record.
Have the courts ever overturned the awarding of a license to operate a long-term care home in Ontario?
That I don't know. I'm not aware of any decision like that. We'll take a look though, and the coalition will post something. We'll try to
It's
figure
weird
it out.
because the licenses, the initial set of licenses were issued, like it was 1997 to 2000 under the Harris Code, right? And then they were 20-year licenses, and then a whole slew of them were extended for five or 10 years. So a bunch of, like right now we're at this period where a whole slew of the licenses are ending. And that was the big privatization to the chain companies of long-term care. So, so many of them would have ended their licenses and closed down, or they would have redeveloped their beds. But most of the licenses really are coming up till now. Like this is the beginning of that. So there really hasn't been, like, as I say, the first time a government in Canada ever paid for-profit companies to build and run a home for their own profit was this slew of licenses that are moving through now.
Yeah, if there was a case interpreting these provisions of the Act, we would know it, so there is no case on the question of eligibility. But under the Act, if the director does determine that an applicant isn't eligible, he can decline or she can decline to issue the license. And at that point, the company has the right to appeal. No one else does. If that could have happened without anybody knowing that an application had been made, that it had been refused, that the applicant had either accepted that decision or perhaps invoked an internal appeal process to review it, that we wouldn't know. But in terms of the courts considering an application such as the one that you've brought, no, there's no precedent.
Sorry, just to clarify, are you saying that under the Long-Term Care Act, the home operator is the only entity that has the right to appeal a decision?
Correct.
Okay, well, thank you very, very much for coming. We really appreciate it. Thanks.
Can I just add one thing? Well, appeal isn't judicial review. So while the company is the only entity that has the right to appeal under the processes of the Long-Term Care Act, any person with standing, anyone affected, or in this case, public interest applicant, such as the Ontario Health Coalition, has the right to invoke the provisions of the Judicial Review Procedure Act to get the court to review the decision to determine whether it was lawfully given. That's a different matter than the question of appeal.
Thanks. Okay, and with that, thank you very, very much for coming. We appreciate you telling this story.